Welcome to session number 44 on liquidation under IBC. Let's quickly recap what we have done in the previous session. In the previous session, we have covered 5 sections spanning section 36 to 40, where liquidation estate, what are the inclusions and exclusions were discussed under section 36. Powers of the liquidator to access the information was discussed under section 37. Consolidation and making of claims was discussed under section 38, verification under 39, and admission, rejection of claims under section 40. This is what we've discussed yesterday. Going forward, we will discuss many other things within liquidation process. Section 41 now deals with determination of valuation of claims. A very important part. As we have understood in section 40, that a liquidator may partly accept and partly reject a claim, or wholly reject a claim or wholly accept a claim. But however, it is very important to first understand the valuation of the claims. Only then he can decide whether to accept or reject the claim. So the liquidator shall determine the value of claims admitted under section 40 in such manner as may be specified by the board. So board only will tell you how do you accept or reject and how do you value the claims. Section 42 says that if a certain claimant is unhappy or is aggrieved by the decision of the liquidator to accept or not accept a certain claim, or partly accept or partly reject a certain claim, then what is that the claimant can do? Obviously, the claimant should now go and appeal. Appeal where? Appeal should be obviously going to adjudicatory authority. We will quickly see how it works. If you look at the picture, we are saying once you make a claim under section 38 and the verification is completed under section 39, under section 40, the liquidator will inform you whether your claim is admitted or rejected. In that case, there are two things that are probably going to happen. Either he will accept your claim or he will reject your claim. Let's look at the rejection. The moment he rejects the claim, you have a right to appeal to NCLT. But on the other hand, if he is accepting your claim, even then you have a right to appeal. Logical question is, if the claim is accepted, then why should I appeal? Obviously, we are saying if the claim is partly accepted and partly rejected, or the valuation of the claim is substantially less than what you have claimed, that's when there is probably a chance for you to go to appeal to NCLT. And what is the time limit within which I can make an appeal? Very important question. You should make the appeal within 14 days from the date of receipt of information from the liquidator. Remember, it is not the date of claim. It is not the date of decision. It is the receipt of the communication of the decision of the liquidator to accept or reject. From there, you will have 14 days to go to NCLT and seek admission of the claim. Straight away, there's a case law, IFCI Limited versus BS Limited, legal provisions affecting section 42 of the code. Then we have adjudicating authority sitting at NCLT Hyderabad. Issues involved are very simple. If the NCLT could exercise its inherent powers and condone the delay of filing an appeal. Let me explain you the issue once again. If your claim is accepted or rejected, you can make an appeal to NCLT within 14 days from the date of receipt of the claim, date of receipt of the communication. But in case you have delayed this appeal, let's say by 10 days, and you go to NCLT to make an appeal, obviously your appeal is delayed. Now, can you seek condonation of delay? Is there any specific provision in the section for condonation of delay? If there is no such provision, can we assume that NCLT has a inherent power to condone the delay. Conclusion is very clear, loud and simple. There is no provision under section 42 for condonation of delay. Honorable NCLT held that when there is a clear statutory bar in entertaining an appeal under section 42 of IBC, which is filed beyond the period prescribed, the NCLT cannot exercise its inherent powers and condone the delay. Therefore, the appeal cannot be made anymore. After the section 42, I have jumped few sections and come to section 52. Let me go back to the previous section that we have covered. We have covered section 42. We have covered a case. After that, we are straight away moving to section 52. I have skipped few sections in between for a reason. The reason is simple. These are called as extortionate, fraudulent, avoidance transactions, which can be avoided by the company, and all the proceeds can be recovered by the company during the process of liquidation if you realize that there are transactions which are not legal. However, those are complex in nature. I have saved them for next session. So for current session, we will focus on section 52 and see what is the position of a secured creditor. Let me explain you before I read out the provisions of section 52, what is the confusion here. If I am a lender to the company, I have lent a loan and I have an asset as security with me, will that asset now be part of the liquidation estate? Or as a creditor, can I walk out with this asset without being part of the liquidation proceedings? Very, very important question, because majority of the creditors who have a secured asset in their hand would not wish to be part of the liquidation proceedings, and they would like to walk away with the liquidation asset. And this can be a major concern for the liquidator. Hence, section 52 makes it very clear, though eventually there were a lot of case laws which have been decided in favor or against the liquidator, but let us first try to understand the provisions of section 52. So let me repeat the confusion. Confusion is secured creditor should take his asset and walk away, or should he participate in the liquidation proceedings and make the asset part of the liquidation estate? So the options at the hand of secured creditor. A secured creditor in the liquidation proceedings may, is not obliged, relinquish its security interest to the liquidation estate and receive proceeds from the sale of assets. Right? So you have an asset, you don't want to take it away, you want to make it part of the liquidation estate, let it go through the sale, and then you are going to wait for the sale proceeds to be coming your side. This is option 1. Or option 2 is realize your own security interest in the manner specified in this section and walk away with this asset, and therefore don't wait for the liquidation proceedings. You can realize your own asset. These are the two options that you have under section 52. While you have these two options, liquidator will always remain in the state of confusion as to what is your decision. Hence, it is your moral and legal responsibility to inform the liquidator as to what is your stand. Your stand is to make it part of the liquidation proceedings, or to realize the asset by yourself. You have to inform your decision to the liquidator as soon as possible. And number 2, identify the asset which you are making part of the liquidation estate or walking away for realization by yourself. While you are making claim on the asset and you want to walk away with an asset for yourself, it is very important to verify the security interest. Before realizing the security interest, the liquidator must verify it. The creditor can only realize security interest that is provable through, remember, you should be able to prove your security interest in the following formats. Only then you can realize your security asset by yourself, otherwise you're part of the regular liquidation proceedings. So part A says, you must be able to prove your claim or asset by way of records maintained by an information utility. If your debt is recorded, your asset security is recorded, and asset is identified, then you can walk away with your asset. Or if you can prove your claim or security interest in any other manner specified by the board, yes, then your interest is verified and then you can walk away with the assets. Lastly, enforcement and application of proceeds. What I mean by that? After you have walked away with the asset, what will you do with that proceeds? Number one, the secured creditor may enforce, realize, settle, compromise, or deal with the secured asset according to the applicable laws and use the proceeds to recover their own debt. Now, watch an interesting scenario. I have lent 5 crores to a borrower. All right? He has given me an asset as a mortgage. Now I have walked away with this asset. When I sell this asset, I got only 2 crores against my 5 crore debt. This is one possible scenario. The other possible scenario is that I sold this asset for 10 crore, whereas my debt is only 5 crores. So one is a case of under recovery, other one is a case of excess recovery. What should be the consequence in both the cases? We will deal with that. Resistance in realization. Let's say if the secured creditor wants to walk away with an asset and realize by himself, and somebody is causing trouble or is actually putting resistance for the process of realization, then such creditor can actually apply to the adjudicating authority to facilitate the realization of his own asset, in which case AA will actually interfere and ensure that your sale and realization process is smooth. What can be the order from adjudicating authority? The adjudicating authority may pass an order to help the secured creditor realize the security interest in accordance with the law, and this makes your life smoother to realize the asset. As I said, when you realize the asset, there are two consequences. One is you recover more than what you deserve, or you recover less than what you deserve. What we are trying to cover here is surplus proceeds, where you've recovered more than what is owed to you. In that case, the creditor must account for the surplus to the creditor or the liquidator and transfer the surplus funds to the liquidator himself, so that that excess money which is recovered by the secured creditor will go to the liquidation estate and will be distributed as part of the liquidation proceedings or proceeds to all other claimants. What happens to the insolvency resolution process cost? The cost of the insolvency resolution process due from secured creditors who realize their security interest will be deducted from the realization proceeds and transferred to the liquidator for inclusion in the liquidation estate. That is an important provision. On the other hand, if what you received is inadequate to meet your own debt, then what happens? If the proceeds from realized secured assets are insufficient to repay the secured creditor's debts, the unpaid debts will be paid by the liquidator as per the priorities outlined in section 53. Now remember, if as a secured creditor, I am bound to recover 5 crores from the CD or its asset, I have recovered only 4 crores, I am left out with 1 crore that I have to receive from the CD, then my 1 crore claim will become part of section 53, and depending on the priority, at a certain stage I will have right to receive my 1 crore which I could not realize from the secured asset. Very, very important provision again. So this is section 52 that talks about position of secured creditor and gives him choice to either be part of the liquidation proceedings or walk away with his asset. To understand this clearly, we have Shrikant Dwarkanath versus BHL. In this case, what happened? It's a case that went to NCLAT and the section 52 of IBC was in discussion. Facts of the case. An application was filed under section 9 of IBC for initiation of CIRP of a company by name SPL. Section 9 deals with, I'm sure all of you understand, it's an operational creditor who is making a claim and who initiates CIRP proceedings with the NCLT. After a CIRP order was passed, no resolution plan was received or approved. The liquidation of the corporate debtor was initiated under section 33 of the Act, which we know. Then BHL, a secured creditor who held 26.24% secured interest in the overall asset value of the CD, he said that I don't want to be part of the liquidation proceedings. Hence, because I have an asset with me, I want to walk away with the secured asset and realize by myself. Then what happened? NCLT or NCLAT, there are two sentences here, watch it carefully. Under the head conclusion, in the first line, the liquidator made an application to NCLT and wanted to stop BHL from taking away the asset. However, NCLT rejected the application of the liquidator and said he cannot take over the asset, it will go to BHL. So liquidator went to NCLAT and made an appeal. Now, interestingly, NCLAT ruled in favor of the liquidator and said that BHL cannot walk away with the asset. How and why? To know the logical reason, you should understand the provisions of section 13 subsection 9 of the SARFAESI Act, which say that a secured creditor to walk away with the asset by himself shall have at least 60% of the value in the asset in the form of a security interest. Only then he can walk away. Now that, as understood previously, he only has 26.24% and not 60% as enshrined in section 39 of the SARFAESI, the NCLAT said BHL cannot walk away with the asset, and hence such asset forms part of the liquidation estate. Now we come to the most important section, which is section 53, also called as waterfall section, which gives you waterfall mechanism, which we have already covered at the time of CIRP, but just for the sake of it, we are going to cover that once more under liquidation so that we know how liquidation proceeds should be distributed. Insolvency resolution cost and the liquidation cost will be met from the liquidation proceeds as a top priority. The first line in the entire table, if you see, the priority is given to the insolvency resolution and liquidation cost. That means one thing good which acts in favor of liquidators and resolution professionals is that their fee is protected to large extent under section 53. They will always get back their money, but if at all there is any proceeds received from liquidation, their money will be recovered. Second, secured creditor, if he has relinquished his security interest, will stand second in priority, but he will stand on equal footing with the workmen whose dues were pending in last 24 months before the commencement of liquidation, right? So top layer is for the insolvency cost and liquidation cost. Second layer is combinedly for the secured creditor and the workmen who had not received their payments in the last 24 months. Then comes the third layer, which is employee wages, any unpaid dues for the period of 12 months preceding the liquidation commencement date. Remember, for workmen we have 24 months, for employee we only have 12 months. And then lastly, we have few more other priorities, that is financial debts owed to unsecured creditors will now come in fourth position. You look at the ranking. Number 1 is insolvency costs. Number 2, secured creditor plus workmen. Number 3, employees. Number 4, financial debts to unsecured creditors. And now number 4, any amount due to the central government, state government. Again, they will rank on par with secured creditor for any unpaid amount following the enforcement of security interest. Like we said under section 52, if the secured creditor walked away with his asset, but he could not realize the full amount, the balance money which he could not realize will now stand on same rank as the government's claims under section 53, which are all on priority. Once you complete payments to all these parties under section 53, then if there are any other remaining debts and dues, those can be paid. Now, ironically, all the investors who had put large amount of monies into the functioning of the company, those will have the last priority, and among those also preference shareholders will rank above the equity shareholders, and last of the claimants can be only equity shareholders. So this is the clear waterfall mechanism under section 53 of the Act, and each party's position is clearly mentioned and when is he eligible to get his claim. Let's move forward now to section 54 of the Act that deals with dissolution of the corporate debtor. Let's quickly recall what is dissolution. If you remember from my first session, that is session number 41, I made it clear that liquidation is a process which comprises multiple events, but dissolution is an end step which completely shuts down the company and its name is struck off from its existence. So now section 54 of the Act deals with dissolution. How was dissolution done? Where the assets of the corporate debtor have been completely liquidated, the liquidator shall make an application to the adjudicatory authority and seek dissolution. Remember, again, this is very interesting. Though liquidator has a lot of powers, liquidator by himself cannot dissolve a company or cannot order dissolution. He can only request the adjudicatory authority to pass an order for dissolution, and the AA will pass the order for dissolution. Now, is it an option for AA or is it an obligation for AA? Remember, the wordings under section 54 are AA shall, on an application filed by the liquidator, order that the CD shall be dissolved from the date of that order. But who will implement the dissolution? Striking of the name is done by the ROC. So when the liquidator makes an application, adjudicatory authority gives an order, and the order is delivered to the liquidator. Liquidator then will take this order to the ROC and informs the ROC that now he has to strike off the name of the company, and ROC will will act on such order and strike off the name from the register. This is what brings an end to a company. To understand this, we have to go to Gujarat Urja Vikas Nigam Limited versus TCS case, where the adjudicatory authority was Honorable Supreme Court, which means that there was an appeal filed to the Supreme Court. Issues involved in the case were, if NCLT has an inherent power to deal with any issues arising out of liquidation process which are not mentioned either in the act or in the regulations, can now NCLT deal with them and take its discretionary power. The conclusion was very simple. The Honorable Supreme Court held that adjudicatory authority has jurisdiction to deal with any issue arising out of the liquidation process. This brings us to the conclusion of session 44. We will quickly summarize what we have learned. We've learned 5 sections today, spanning section 41, 42, 52, 53, and 54. 41 tells us how do you determine the value of a claim. 42 tells us how to make an appeal to adjudicatory authority if you're not happy with the decision of the liquidator in case of a claim. Section 52 talks about the position of the secured creditor in liquidation proceedings. He can be part of liquidation or he can walk away with his asset. And section 53 tells you how to distribute the assets or sale proceeds of the liquidation estate. And lastly, section 54 deals with dissolution of the corporate debtor. Liquidator makes an application, AA passes an order, ROC will implement the order, and this is what brings an end to the company, also to session 44 of ours. We will meet in session 45. Thank you.